Section 13 of the Act, which deals with divorce, has been amended many times. Initially, it was restrictive in scope and even cruelty was not recognized as the ground for the dissolution of marriage. Gradually, Section 13 of the Act was amended and new grounds were incorporated. Section 13 reads as: divorce. Any marriage solemnized, whether before or after the commencement of this Act, may, on a petition presented by either the husband or the wife, be dissolved by decree of divorce on the grounds that the other party 1. Has, after the commencement of the marriage, had voluntarily sexual intercourse with any person other than his or her spouse, or has, after the solemnization of marriage, treated the petitioner with cruelty, or has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petition, or has ceased to be a Hindu by conversion to another religion, or has been incurably of unsound mind, or has been suffering continuously or intermittently from mental disorder of such a kind and to such an extent that the petitioner cannot reasonably expected to live with the respondent. Explanation. In this clause, the expression mental disorder means mental illness, asserted or incomplete development of mind, psychopathic disorder or any other disorder, or disability of mind, and includes schizophrenia. The expression psychopathic disorder means a persistent disorder or disability of mind, whether or not including subnormality of intelligence, which results in abnormally aggressive or seriously irresponsible conduct on the part of the other party, and whether or not it requires or is susceptible to medical treatment, or has been suffering from a virulent and incurable form of leprosy, or has been suffering from venereal disease in a communicable form, or has renounced the world by entering any religious order, or has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive. Explanation. In this subsection, the expression desertion means the desertion of a petitioner by the other party to the marriage without reasonable cause and without the consent or against the wish of such party, and includes the willful neglect of the petitioner by the other party to the marriage, and its grammatical variations and cognate expressions shall be construed accordingly. Either party to a marriage, whether solemnized before or after the commencement of this act, may also present a petition for the dissolution of marriage by a decree of divorce on the ground that there has been no resumption of cohabitation as between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for judicial separation in a proceeding to which they were parties, or that there has been no restitution of conjugal rights as between the parties to the marriage for a period of 1 year or upwards after the passing of decree for restoration of conjugal rights in a proceeding to which they were parties. A wife may also present a petition for the dissolution of her marriage by a decree of divorce on the ground, number one, in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that other wife of the husband married before such commencement was alive at the time of the solemnization of the marriage of the petitioner, provided that in either case the other wife is alive at the time of presentation of the petition, or that the husband has, since the solemnization of the marriage, been guilty of rape, sodomy, or bestiality, or that in a suit under Section 18 of the Hindu Adoptions and Maintenance Act 1956, or in a proceedings under Section 125 of the Code of Criminal Procedure 1973, a decree or order, as the case may be, has been passed against the husband awarding maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such decree or order, cohabitation between the parties has not been resumed for 1 year or upwards, or that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she had repudiated that marriage after attaining that age, but before the attaining of 18 years. Explanation. This clause applies whether the marriage was solemnized before or after commencement of the Marriage Law Amendment Act 1976. The Marriage Laws Amendment Act 1976 also incorporated divorce by mutual consent as one of the modes for the dissolution of marriage. Section 13b, subsection 1 reads, subject to the provisions of this act, a petition for dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the Marriage Laws Amendment Act 1976, on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed that the marriage should be dissolved.